like. We've got a list of questions already, but that will help us to know what everybody really cares about. So use the chat, use the Q&A feature, and upvote. And then finally, Victor is a contributor from the group, from the Law Insider group. All of you can be contributors as well. We're trying to, like I said, crowdsource all this wisdom that you guys have. So if you guys want to be in a webinar or write a blog post, if you hear something interesting that Victor says and you go do some research, you want to share it with everybody, let us know. We can put that into a blog post and share it with the other users. So just reach out to us. Preston, I'm going to turn the time over to you. If somebody wants to be a contributor, what's the best email for them to reach out? And then we'll get to your announcement.
Yeah, best email, Mike, is community@lawinsider.com, and that's a great segue into what I want to talk about here for just a minute. Thank you for giving me that opportunity. So before Mike and Victor take the show here, obviously you all are here to learn about SaaS contracts, and that's something that is near and dear to me. But before we get started, the reason you all got invited to this is at some point in time, you registered with Law Insider. We are a contract database and clause database, as many of you know. Some of you may not know that. Some of you may have stumbled on this by accident, but in all respects, that's the one common thread that we all have in common, is that to some degree in our lives, we're drafting and negotiating agreements. And the powerful idea that we are starting to launch at Law Insider is, can we build a community around drafting and negotiating contracts? And that may seem like an unremarkable thing to be building a business or a community around, but we think not. We think that so much of our lives, our business lives and our personal lives, relate to how we draft and negotiate, that it's worth going deep. And so bringing experts like Victor and others together, we think is a really powerful idea. And the reason why we believe we're the right group to do that is because we've built this massive database where we continue to add literally hundreds of new people sign up on lawinsider.com every day, who are looking for contracts or looking for templates, that are looking for legal definitions. And so we think that this is a pretty cool idea. But the question is, how are we doing it? How are we manifesting and building a community? And one way is we're building out a blog. That's at lawinsider.com/resources. There are some really great articles there already from all of you. This is crowdsourced. We certainly curate and review all content that's published, but it's an exciting way for all of your knowledge to be brought together in one place. The newsletter goes out bi-weekly. You should all be receiving that. If you're not, maybe check your spam filter. These webinars, Mike is leading this webinar initiative. If you are in any part of the world, in Kenya, in Mumbai, in New Jersey, wherever you might find yourself, and you are an expert relating to drafting and negotiating agreements in any vein, like Victor is relative to SaaS agreements, we would love for you to participate either as a writer or as a webinar host or presenter. And we're going to be launching a customer advisory board very soon. This is so we can learn about what products and services we should be offering. Maybe you think we should do a podcast. Maybe you think we should add a new product feature to lawinsider.com. We're here for that. This is about serving this community we think we're uniquely positioned to serve. And we also would be very open to your feedback on what else we should do. So at the end of the webinar today, you're going to be prompted with a survey. Please it probably takes you 2 minutes to go through it. Would really, really appreciate your feedback there. Mike, that's it. Thank you for the time. As Mike said, if you want to contribute, you can email us at community@lawinsider.com. If you want to reach out to me, my name is Preston Clark. I'm a co-founder of Law Insider, also an attorney, former general counsel. I can be reached at preston@lawinsider.com. Mike, that's it. I'm going to stop sharing my screen. The floor is yours.
Perfect. Thank you, Preston. Again, we're going to turn some time over to Victor here. Before I do that, just a reminder, use the chat feature. It pops up on the right side. You guys can talk about what we're talking about, talk about whatever you want to talk about, really. If something comes up that you want to dig into, just start chatting with each other there. And a reminder, use the Q&A feature if you want to ask questions, and please upvote the questions that interest you. So we'll do about 30 minutes of Victor giving us some background info on this. Victor, hi. Are you able to share your screen? Did we get that worked out?
I don't think I can at the moment, but we can start chatting first, and you
Okay.
guys can sort of figure
Yeah,
that
I
out.
was hoping that you would tell us just a little bit about your background a bit, and there's a lot of ground to cover with SaaS contracts, so I'm gonna
For
give the floor
sure.
to you, brother.
Thanks, man. Yeah, so my name is Victor. I am an attorney at Goodwin Procter in the Silicon Valley. I've been practicing for about 5 years now. I started my career not in technology transactions at all, actually. I was doing IP litigation for a little bit. Got a little bit of PTSD, as people do, doing litigation, and so made the switch out to something more near and dear to my heart. I have a lot of friends who are obviously in startups and in the startup ecosphere in the Bay Area, and so um, I took an interest to startup world. So started doing tech transactions a few years ago. And obviously with the world the way it is right now in terms of technology, SaaS is like a huge part of my practice. So really ranging over all sorts of different variations of it. So for example, um, you know, we deal with a lot of the early stage startups who are sort of engaging their very first customer, which is its own sort of set of issues and set of things you have to deal with. And then also obviously bigger customers who might have a really meaty 50-page, $1 million contract that they need some eyes on. So I've really seen the gamut of how these things can go. And there's this presentation could be probably expanded out into some sort of a 10-part series, which I don't want to do. But for purposes of 30 minutes, I really wanted to highlight what I felt like I see a lot of traffic through my emails about. So for example, I saw a lot of questions about this as well, but there are a ton of issues around indemnities, liabilities, warranties are all kind of confusing when you first approach these things, and so I wanted to bring a little bit of clarity to it. So that's sort of how we wanted to start this. Okay, great. I can share my screen now. So let's get started. And obviously, I'm going to be talking for 30 minutes. And Mike, you're super smart and super handsome, so please jump in and break up the monotony when you can.
It's hard to argue. Hard to argue.
All right. Does everyone see this presentation? I think it's good to go. Cool. All right. So agenda. What I wanted to do first was start talking about leverage, right? I think it's important to know who you are, and so obviously I'm an attorney at a law firm, and so I'm always talking sort of from the perspective of an attorney guiding a company, and so you obviously might be in-house. I see some of you guys, you must have a love for passion for SaaS contracts if you're in Lebanon right now and tuning into a SaaS contract presentation. So big ups to you. But knowing who your client is super important. So whether you're in-house or you're like me in a firm, the honesty that you have to bring to the table of what leverage your client has is super important, because again, with the example that I laid out earlier, when you're a startup and you're a big company, there's really different ways that you look at the drafting. So we'll talk about the risk shifting provisions, and by that I mean the warranties, indemnities, liabilities. And then one big topic I think is on top of everyone's mind is like, what do we do with the data? There's so many variations and laws related to data privacy, and obviously I'm not going to go into the details of GDPR and all that stuff, but at the core of it, what can we do with your customers' data to improve your services and all that good stuff? And then I'll touch on a few other common areas that Mike and I think found on the question list. And then after that, we can go into the Q&A. So let's start with leverage. Leverage always dictates drafting. And so what I mentioned earlier, there's the way I envision it, there is a spectrum, right? So for example, you might have a situation where your customer has a ton of leverage. You might have a situation where the SaaS company has a ton of leverage, and how that plays out in the negotiation really dictates how we're going to set up maybe your customer's form agreement, how we sort of scale back certain terms or add certain terms. And so what's a situation where the customer has leverage? Well, let's say your client is an early stage startup. Let's use an example of what I like to use often is you know, we see all these fancy machine learning SaaS companies now. And so we'll use the example of, let's say, a company that's helping you sift through your security footage to find people that don't belong where they're, you know, they're seen on a security camera, for example. And let's say it's a 3-person team that just graduated from a fantastic university and they're selling to the Facebooks and Amazons of the world. Well, in that situation, you know, you're up against lawyers with, you know, 10 times my experience and an entire team, and you really don't have that much leverage, and you kind of have to eat all the terms that they give you. So that's important context to have walking in. And in this context, you really have to optimize for frictionless sales. You don't want to have like a prolonged 3-month negotiation where you're not earning a penny and you're spending, you know, really important resources on sales when most of the time the startup is filled with engineers. And you're also optimizing for your reputation. It's your first customer, right? You got to land that customer. And if you could say to anyone, you know, that, hey, I landed, you know, Facebook, you're off to the races, and that's something that you really want to learn or you really want to gain. But at the same time, you don't want to shoot yourself in the foot with terms that are just, you know, if you breach it, you know, that's the end of your startup. So that's the customer leverage situation. There's also the situation where the company has leverage, and this is, you know, a lot of us, especially us lawyers going through law school, I'm sure we were all very appalled when we learned that, hey, when we click I agree and we don't read the contract, we're actually agreeing to all of it. And so, you know, those are situations where the company has a ton of leverage, and you know, you see that in your big Fortune 500 companies, and they're selling to basically businesses that are either smaller than them or just simply don't have the leverage. So it's more of a take it or leave it. And so you're really optimizing for terms that are purely protective of your company. You're not really giving on anything, and then it's probably going to be presented in a situation that's like a click wrap or a click through. So that's sort of the two polar ends of the spectrum, and there's obviously a huge gamut in between where there's a lot of variance. So we're going to talk in a little bit of absolutes when they're, you know, they're really not, but I think it's helpful to frame it like that before we dive in. And I should say right now, you know, I'm going to be mentioning quite a few companies. Obviously, you know, some of these companies I might be across from, they might be my clients, and obviously nothing I talk about right now is representative of anything I'm working on in real life. And so purely for example purposes, but I hope it helps illustrate it well enough for you guys. Okay, so let's dive into the risk shifting provisions. And I think the first one that's on top of mind is reps and warranties, and then we'll go into the indemnities and liabilities. So reps and warranties, how do we think about the balance, right? So let's think about a situation where your customer has a lot of leverage, and just taking a step back, reps and warranties are a little bit weird when we're talking about a SaaS contract, right? Because they're really a holdover from the old world where you buy a product and you have a warranty and the product doesn't work quite as that you thought it would, and so the company guarantees like a warranty, and then you can call the warranty line and get your product shipped, fixed, or whatever that may be. And so in the software world, when that got ported over, it was really, you know, hey, I'm going to go buy a CD, you know, in a store, and I'm going to upload it, and if there's an issue, then there's a support line that you call, and then you figure out, you know, how you can get that fixed. The SaaS world gets a little bit even more departed from the physical world, where you're not even really having your customers download anything, right? You're logging onto your website and you're logging into a portal like Law Insider, for example, and so there's not really a situation where, you know, there's a functioning thing on your computer that you need fixed, and so it's really it's a little bit different, but there are a lot of things that are similar, and so we'll walk over those things right now. So when a customer has leverage in a situation, let's talk about that early stage startup selling to a big company. You have to warrant for absolutely everything under the sun, and unfortunately, that might be just the reality that you have to live with for your first few customers, and that's you know. That could be problematic depending on what your business really deals with, but oftentimes, you know, there's ways we can work around it. Now, The first thing is a warranty disclaimer, right? We always see that in a contract with all caps. You know, the software is provided as is. We don't promise that it's going to work at X, Y, Z. Disclaimers are important no matter what leverage you have. It's going to be in every single contract, right? And so, you know, you might have additional warranties that sort of sit outside of the disclaimer, but overall you have this sort of umbrella disclaimer that says, you know, I'm not going to guarantee that, for example, my tax software is going to save you, you know, this many tax dollars a year. And, you know, if you don't meet that metric, it's not necessarily a situation where your customer can say, hey, you breached my warranty. It's more like, you know, it might be a performance issue, but it's not something that would arise to the level of a breach of an agreement. So the disclaimer is always there, but what are the sort of warranties that other warranties that we see? One would be a non-infringement. In this situation, you know, you are providing software as a company. You designed it, you coded it, so you have to warrant to your customer that, hey, when you're using my stuff, I'm going to warrant to you that my software doesn't infringe some third-party IP. In other words, you should feel comfortable using it without any liability related to another third party's IP. The other big ticket item, this one is somewhat of a red flag to me when I'm a lawyer looking at this, is compliance with all applicable laws. And I purposely drafted that very broadly because that is often how it's drafted. It could be data privacy laws, it could be financial laws, it could be HIPAA laws, right, if you're dealing with privacy information. So in other words, you're representing that your customer using this software is not going to breach any applicable laws related to the service. So it can really rope in a lot of different liabilities and is kind of a scary thing. One other warranty that we sometimes see is a no malicious code warranty. And so this would be, you know, malicious code can be viruses, bugs that somehow screw up the computer of your user. Again, when we're talking about a situation like Law Insider where you're not actually downloading anything, this really might not be that important, right? Because you know, there's not that many scenarios where malicious code would harm the user when it's purely cloud hosted. But there could be software. You know, let's take the security camera footage company as an example. You know, they might actually have devices that are on the company's premises, and so they might be connecting to the company's internal servers. So in that situation, it might actually be more important to have a rep that says there isn't any malicious code. And then the last sort of section of warranties is what I call performance warranties. And it often will say, so it's sort of like a broad term, but it will say that, hey, my software is going to perform in accordance with my documentation. And so that could be, for example, you might have a website that has a listing of these are the functionalities that we see, and you're basically promising that your software is going to perform in accordance with that. And so those are the if you're a situation where your client is a company selling to a customer with a ton of leverage, you might have to do all of these things. So what is a more balanced scenario? Now we're talking about a world where maybe the two parties have a little bit of equal bargaining power, right? And so from a company's, if you're representing a company in that scenario that's selling to a balanced customer, you might scale this back a little bit. Again, the disclaimer is par for the course. I think everyone has a disclaimer. Non-infringement, maybe, and we'll talk about this later, but non-infringement is often more negotiated in the indemnity section, but sometimes it might show up as a warranty as well. You might not give a broad compliance of law warranty in that scenario. You might not give a no bug, no virus warranty in that scenario. Performance warranties are also somewhat par for the course, actually. You might even, you guys can browse it on your own time, but if you look at AWS, you look at, really the big animals in the space, like Zendesk, for example, they'll give a performance warranty, and we'll talk about how sort of the drafting tips that companies do to sort of limit the exposure of that, even though they are giving some minimal warranty there. And okay, a situation where the company has a ton of leverage. They're selling to a customer that really has a take it or leave it kind of scenario. Again, you have the disclaimer. You might not give non-infringement, but you might not give all those things. But again, the performance warranties are there. I just talked about sort of the AWS situation. So those will still appear in pretty much all of contracts. Maybe not all. I do have scenarios where a client is selling to a really small business, and in that scenario, they might be super stringent with what they're going to give, and so that's sort of how it shakes out with the reps and warranties. So drafting tips. The drafting tip I have here is really related to the performance warranties. So again, we're talking about a big company like an AWS, $1 billion company. So why would they give a warranty on their performance? Well, the reason why you want to do that is you basically want a scenario where maybe your software isn't working that well, and you don't want your customer to come and say, hey, you breached our entire agreement, right? And you shouldn't be sued, but if your software is slightly underperforming. So the fix is under the performance warranty, what they'll say is that your sole and exclusive remedy is for us to fix this problem. And that's pretty much it, right? So in other words, if we didn't meet our performance warranty, that's fine. You can tell us about it, but we're just going to fix it. And that's the only thing that you can do. You can't seek damages. You can't say that because it didn't perform, X, Y, and Z happened to our company that really damaged us and you got to pay us for it. You can't get in on all those things. You only have a sole and exclusive remedy. So I think this is an important tip, not just for a situation, when you're a huge company. I think when you're a startup as well. I think it's fair to say that, right? It's fair to say that, hey, look, if there's a problem with our software, then we can fix it for you, but we're not going to give you a huge bite of the apple there. And the other performance-related drafting tip I have, I saw a few questions proposed about this, but there's a concept in a lot of SaaS agreements called an SLA, and that typically stands for a service level agreement. And what that is typically it's about how often your service is available. And so what that means is, let's say, taking the AWS example, if AWS is down for, let's say, even 5 minutes in a day, I mean, half the internet is down, right? And that's a massive problem for every one of AWS's customers. And so in that scenario, if you didn't have some sort of a availability guarantee that sets out, sort of what percentage of downtime is allowed and sort of what happens if it doesn't meet that percentage of time, then your customers can really come back to you and say, hey, look, your service was down for super critical parts of my business time, and I'm seeking a breach of the agreement. So SLAs are an important mechanism for a company to basically set out the parameters of what that availability looks like. So if we're talking about AWS is super important, but maybe for Law Insider that might not be as important, right? Because you're not logged into Law Insider, every single waking moment. You're really just pulling things in time. And so I think that's also important for a startup to have. A lot of startups ask me, hey, look, I don't know what my availability looks like. We're on V1 of the software. It's going to break down like all the time. So how do we think about that? Well, a lot of your sophisticated customers are going to ask for that, right? And so if they're going to ask for it, no matter what, I've always thought of it as a better position to sort of put our first offer in front of them rather than taking their first offer. So if you can just have some really baseline guarantees about how often they're available, let's say over a month, I will only be available for 99% of the time. So when that's calculated over the length of a month, that's about like 5-6 hours, right? So it's actually a decent amount of time for a software to experience unannounced downtimes. So those are the things that we can sort of rein in the reps and warranties. Indemnities, big topics, a similar framework that we got to work through, customers and companies, and which one has leverage. So let's talk about a situation where, again, you're selling to a big company with a lot of leverage. Again, they're going to ask for everything, right? They're going to ask you to indemnify for all of these things. And just to take a step back, I think one of the things that confused me when I first started practicing and negotiating SaaS contracts was like, well, what's actually the difference between indemnities and warranties, right? A lot of these things that you see listed here are the same things. In the SaaS context, typically a warranty is something that you give to your customer directly. Whereas an indemnity is sort of covering situations where a third party might sue your customer for their use of your product, right? And so this is really contemplating third party liability. So just to give you an example of third party infringement, right? I provide a software to you, but as you are using it, one random third party with a random patent somewhere in the world sues you as the customer for your use of the company's software. And so the customer is like, hey, look, I didn't build this. I just signed up on a subscription online. Like, I shouldn't be sued for this stuff, right? And so in that scenario, it's fair across the board that the company that's providing the software is going to cover that customer for that type of liability. And so that I feel is par for the course. I rarely see a SaaS agreement where the company isn't indemnifying for third-party IP. It's just hard to argue out of in that context. The other things that are huge liabilities, but we're seeing trends where it's really common, is indemnities for data breach and breach of law. I kind of think of that as also a data breach thing, because obviously if you have a massive data breach, you're probably in violation of the law as well. So they come in sort of tandem. The other two that are broad catch-alls that you'll see a lot in a situation where your customer has leverage. I have a lot of startups who sell to these big companies where the big companies like, look, any liability that comes out of a breach of your warranty, what we just talked about in the previous slides, any liability that might even come from your just breach of the agreement, just broadly, any third-party liability that comes from the breach of the agreement, you have to cover us for. And when I'm helping startups with this, I always try to push as hard as I can on those things, because they're really umbrella sort of liabilities that it's hard for the company to foresee. For things like IP infringement and data breach, you have a good argument that you can see where that's coming from. But catch-alls like warranty and breach of agreement, those are things that we try to push off. But a lot of times those are things that you have to eat when your customer has a ton of leverage. A more balanced scenario, again, we cut out the breach of warranties, we cut out the breach of agreement, we might even cut out the breach of law, because breach of law might be a little bit too broad. Data breach is a bit up in the air. I think it's really company specific. If you're a SaaS provider that you're selling super sensitive data analytics with about healthcare stuff, or your dental software where your customer is a dental practice that's sending you just reams and reams of images of individuals tied to their names, right? That might be a scenario where, hey, look, you're just going to have to cover for data breach, right? That's a scenario where you decided to start a company that's super sensitive, so you're going to have to pony up and have some insurance in place to cover that scenario. And then third-party IP infringement, like I said before, that's kind of par for the course. I think every customer asks for it, and I think it's kind of fair to give that. And then, okay, what about a situation where you're a massive Fortune 500 company selling to a small customer? I think it's, data breach, again, data breach can be there. It might be, it might not. When we're talking about, the true unicorns of the world, they're not going to give that type of a liability. They're not going to give that type of indemnity. Third-party IP infringement, again, is par for the course. But what you'll see in this situation is the companies are going to actually ask the customer to cover them for certain scenarios. And so it's almost the inverse, right? You're asking your customer to indemnify you for certain things. So, let's take a huge cloud provider as an example. Let's say the cloud provider is selling to a customer, but the customer is using it for super illegal things, right? Maybe they're using it to store a database for illegal drugs or something that they're selling on the black market. And maybe in that scenario, the government goes after the cloud provider. They go after AWS and they say, hey, look, you allowed your customer to be doing this on your platform, right? And so, when the company has a lot of weight and there's a possibility of that type of liability on their services, they might ask the customer to cover them if they do anything illegal using the software. And so, a lot of times when I'm helping negotiate on the customer side in this situation, we basically have to have a pretty frank discussion of, hey, look, what are you going to use this for? Do you think you're going to trip up in any way that would bring up this kind of liability? Typically, if it's in a situation like AWS, you're just going to have to use AWS no matter what. They offer superior service, and so you just have to be cognizant and really counsel your client to figure out whether these are going to be issues that really make it, hey, look, maybe we go for a different service, right? So those are sort of how the indemnities shake out. So drafting tips on the indemnities. Again, IP infringement is part of the course, but there are ways that you as the service provider, as the SaaS provider, can limit the scope of your IP infringement indemnity. So let's sort of play out a scenario. I give Mike the software that I created and I designed. Mike's using it and he gets sued. And in the lawsuit it says that, hey, this component A infringes a third party's IP. And so me as the SaaS provider, like, I don't want that scenario to be completely unbounded where I have to pay for millions and millions of dollars, right? So the situation there, I might guarantee to Mike, look, hey, I'm going to do my best to secure the rights for you to use my software so that there's no situation where you're liable. So that might be, maybe I settle with this guy, right? Or maybe I buy a license from this third party who's suing me. So Mike still can continue to use the software without worrying that him using it is going to expose him to some sort of a legal claim. Okay, maybe that doesn't work. Maybe the third party's not going to give me that. They're really angry, right? When I'm doing something truly evil here. That might be a situation where I say, okay, Mike, component A, you can't use that anymore, but I'm going to replace it for you. I'm going to replace it with something that's not infringing, and you can continue to use the services. There's not going to be a problem here. Our engineers have figured it out, so you're out of the scope of this situation. And then, okay, let's say option 1 and 2 don't work. I can't secure the rights for you to use it. I can't replace it with a non-infringing part. Then I might say, hey, look, I'm going to give you a refund. You don't have to, I'm sorry, you're going to have to stop using our services because they're infringing. But again, this magical language, hey, this is your, quote, sole and exclusive remedy, right? I'm going to give you a refund. I'm going to do all these things for you. But that's really the bounds of what I can provide you as a service provider. And you'll see this sort of language, this sort of structure in a lot of SaaS agreements. Again, bargaining leverage matters. When I'm representing a startup and I try to throw this concept in with a big ticket customer, that doesn't typically fly. But hey, might as well try. And so data breach as well. A lot of people, rightfully so, there's a lot of concerns about indemnifying for data breach. Again, if you're dealing with not so sensitive data, let's say, the only things you're really collecting is maybe their name and their email, when they sign on, when they sign up for the service, you might not care so much. But if it's super sensitive, then we want to start talking about what that liability looks like. And so that sort of leads well into this last risk shifting thing, limitations of liability, and how do we do with that? There's 2 limitations of liabilities that I'm sure all of us have seen. There's another all caps section in a lot of these contracts. It's funny because every time there's an all caps, like my eyes kind of glance over it, even though it's supposed to emphasize it more. But definitely don't do that as a lawyer. You want to read those things in excruciating detail. But there's 2 things to consider. There's a special damages liability limitation, and there's a sort of an aggregate liability cap. And the cap is more like the dollar amount. Like how much what are we talking about in terms of real money here? But we'll start with the special damages. I'm sure you've seen this before, but it's basically saying, the company is saying, hey, look, even if we breach this agreement, we're not going to pay you for things that are not foreseeable, right? Taking the tax company, the tax product, if you lost profits because, because of our software, like we couldn't foresee that you lost $5 million because of that. We're not going to pay you for that, right? So these are sort of the special damages that we've all heard of in law school, the indirect damages, the consequential damages. These are par for the course. I always see these limitations of liabilities in every single contract. The question is, what types of liabilities get carved out of this? And so we'll touch on that in a second. That's really where the negotiation comes into play. It's like, is data breach outside of the scope of this limitation? Because, maybe if it is, then if your data breach caused you lots of lost profits, that might be fair game in that situation. And the other thing was the aggregate liability. What's the actual dollar amount we're talking about here, right? And so I took this from a generic example, I think off of Law Insider actually. But this one says basically the dollar amount, what I've been seeing as a trend is it's typically tied to the amount of fees that the customer pays over a certain period of time. What I see a lot is just 12 months fees paid. Like our maximum aggregate liability as a company to the customer is what you paid in the last 12 months. And so the exceptions again become super important because, if you paid me $20 for the span of 12 months and I'm telling you, hey, look, you got a data breach, but I'm only giving you $20, like that's a non-starter, as we say. So when we're talking about exclusions, there are a lot of common exclusions, and we see this a lot when the customer has a ton of leverage. They'll exclude everything under the sun. You have IP infringement, you have breach of an agreement, you have breach of representations, breach of confidentiality, breach of law, data breach. Those things not included in the limitation. Those things we get maximum liability all across the board. Again, I'm very scared of breach of agreement and breach of representation. So when it's a balanced scenario, like I definitely want to try to carve that out. That would be very scary for me if I'm a company selling a service. And then what you see in situations where a company has a ton of leverage, they might even cut out data breach, right? Because data breach is really the big behemoth that we have to talk about. But what I do see is IP infringement and breach of confidentiality. Those are often things that are commonly excluded, even in the most, even in a situation where the company has a ton of leverage. And the rationale behind that is, again, IP infringement, it's our software. Like if we did something truly egregious and my customer's on the hook for it, they shouldn't be limited in what they can recover there. Breach of confidentiality, if you as a customer, you gave me a bunch of confidential information, and this is a little bit different from data breach, but let's just say, there's something about your business that no one else knows about, and somehow someone came upon it. That might be a situation where arguing that, hey, that liability needs to be limited, that's probably not very fair and not a good place to start. But we had some questions about, okay, so how do we deal with drafting these things? And is a super cap is something that we talk about nowadays. So what is a super cap? So we talked a little bit earlier about the aggregate liability cap, and we're looking at like 12 months fees paid, right? And so you're telling me, okay, I pay $20 in 12 months. You gotta give me something more here. And so the negotiation kind of goes like that. The customer wants something more. They want to exclude data breach, right? And then me as the company, I'm saying, okay, well, I'm going to let you exclude data breach, but I'm not going to give you unlimited liability, right? We've seen scenarios, plenty of scenarios now where, data breach is on the order of magnitude of tens of millions of dollars. And, if you're a startup, $500,000 to $1 million could be the end of your company, full stop. And, try to go back to your investors and ask for more money after you've had a major data breach. Like, I think that's probably the end of your startup. And so we talk about this concept of a super cap, basically saying, okay, fine, you'll get data breach, but we'll have to cap that data breach at a certain level. And so, that number is really hard to calculate. But I would say that the market range right now is about $500,000 to about 5 million. I have seen it go up to 10 million too, depending on how, how much volume we're looking in terms of data and how sensitive the information. So that's definitely a trend. There's definitely something where if your customer is asking for something as broad as data breach, I would say, let's talk about what that super cap looks like, and at least it gives you some idea of what the worst case scenario looks like for your company, and hopefully that number is not something that's going to be completely ruinous for your business. Other types of caps is, sometimes people will say, well, what about IP infringement? We're not going to, if I get sued for IP infringement, I need more than $20. Well, we can talk about, some multiple of the fee cap. Sometimes you'll say, hey, 2 times your 12 months, or so 24 months, or 36-month fees paid, like whatever that number might be. So that might be a way to at least manage the exposure. And so the last quick topic, I know we have a lot of time, but the last topic I really wanted to brush over is data rights. And it's actually somewhat simple in my view, because the way I look at it is you really split the world of data into 2 things. You talk about, there's 2 things. So there's the raw data. So let's do the computer vision company, the security footage company. They need to run their business with raw data. They need your video feed. They need to see faces. They need to see how people walk. They need to see, where they are in your business. They're going to need raw data, and that's something that the customer should probably understand if they're going to be paying them money for the service. But there might be situations where you really don't care about the raw data, and you really just care about the performance of the product, right? Like for a cloud provider, you don't care what they're uploading, but you really do care about, hey, look, they uploaded this 20 gigabyte file and it took them a year to do. And so the question is, whose data is that, right? Is that the customer's data? Is that our data? And if there's any ambiguity, we as lawyers, we have to bring clarity to that, because we don't want a scenario where a customer can come back in the future and say, hey, look, you used our performance metrics, you didn't have the right to do that, and now we're in version 10 of our software, and that could be a kind of a scary scenario. The art of subtlety really matters here. I think the client should always own their data, right? If you have a contract that says that the company owns all their data, that's not going to fly in this day and age. But I think it doesn't impede what we can do as a company and a service provider. So when we draft our data rights, we have to think about the raw data and the performance metrics. And so this is some of the sample clauses that I typically use in this scenario. Hopefully it's helpful for you. But if machine learning is important, what I've done lately is I really emphasize that. I've said explicitly, hey, look, machine learning is an important part of our product. I say that straight up in the contract. And then I say, look, the customer gives us the right to train our algorithms with the data that you submit through the services. It's really important to have a technical discussion in this kind of scenario, right? Because if the customer really doesn't know that, then that can be kind of a scary thing to put in a contract. But if you're in your customers and your engineers have that discussion that, hey, this is what we need to do. We're going to do whatever we can to protect all the information that we need to protect, but hey, we need machine learning, and that's just what it is. I've actually felt that being more upfront about it has actually pushed this through in deals pretty consistently. So honesty definitely helps there. For performance metrics, let's say you don't need the raw data. That's a scenario where you need really 2 things, right? You need the right to use those performance metrics of your software to improve your services. But let's say next month you're going to put out a marketing copy, and you're going to say, hey, my tax service saved our customers 20% over the course of a year. You're actually kind of using your customer's data in that scenario, right? And you're actually disclosing it to the public. So what if your customer comes back and says, hey, you just had this huge commercial where you talked about your customer data. Did you actually use our data in that? Right? And so that might be a really shaky scenario where we might actually disclosing information. So we always want to say something like, we're disclosing your information, but only in aggregated and in anonymized format, right? There's no one that can reverse engineer that to say that the customer had that data or anything like that. So those are sort of my quick thoughts on drafting tips for data. Other common issues that I think we touched on briefly in the questions. Termination for convenience. Should your customer be able to terminate at any time? That's kind of a business call, right? If your customer is like, hey, look, I'm not comfortable signing on to 12 months. I want a way out of this. you might have to give that. You try to push as hard as you can as a business, but that might be something that you need a reality you need to live up to. But one thing, the one way to limit that is to say, okay, fine, you get to terminate, but you don't get a refund, right? So let's say you terminated, today's July 2nd. You already paid your full July fees. You're terminating on July 2nd. You can terminate, but we get to keep our fees for July. So that might be one way to scale it back. In terms of publicity, as a startup or any company, you just signed a huge customer and you want to publicize it. You want a press release. You want to go on Twitter and tell everyone, hey, look, I just signed, this massive unicorn. I always push for that, and oftentimes the customer wants consent, and I'm like, fine, so long as you give us consent. But I always want that option for especially our smaller clients, because that's actually an important part of the business deal. And then the last bit is the force majeure. Everyone's thinking about this nowadays. What about COVID, right? Like, what if the company can't do the services because of COVID? I think it's kind of a hard sell. I mean, you and I are on Zoom right now. Everything's working just fine. You can log into Law Insider and pull whatever you want right now. The internet's running just fine. AWS is up and running. So I think it's kind of a hard ask for a pure cloud-hosted SaaS company. Now, if you are a software company that's also doing on-premise stuff, taking the security camera footage company, and you actually have to go on the premises and you have to install cameras and you have to do things in person, then okay, that might be a scenario where a pandemic might be something that is hard to navigate around. So it's more context specific. But for a typical cloud-hosted SaaS product, hard sell. But yeah, so that's the gist of the presentation. Open to any questions and comments.
Thank you, Victor. You guys, we have a lot of questions. We got a lot of questions before we started. We got a lot of questions since. There's a lot going on here. What I hope you guys will do as we shift into addressing some of these questions, what I hope you guys will do, as I'm looking through the Q&A section, there's a bunch of people giving answers. Roman's very active in there. I'm seeing Hasib quite a bit. Michelle is in there. If you guys have a lot of thoughts to add to these areas, I hope what you will do is email community@lawinsider.com and become contributors. As we can answer these questions, we can share those answers with each other. So in the next 10 minutes, what I'm going to do, guys, is get to some of the questions that were coming up the most often. So Victor, on that question that you mentioned, in COVID, it's hard to, try to get out of stuff. I were trying, the thing with force majeure is we can't say these things are unforeseeable anymore. We know COVID is coming, right? Like it's here.
Sure.
And so you might have to think about that. Would you want to incorporate anything into the SLA in terms of, like, if I actually have reduced capacity and can't deliver on the service, how might practically you incorporate that future outage issue?
Yeah, that's a good question. We've seen some force majeure clauses now have like special carve-outs for COVID. So there might be scenarios where this current pandemic is actually foreseeable, right? And we've been at this for 4 months now, and after 4 months, you should probably have your game together with respect to your services, right? And so, in that scenario, I think you're right. I think pushing it to an SLA might make sense in that scenario where it's like, hey, look, we have to have a frank conversation. There are components of our software that we're really struggling with COVID. So maybe let's renegotiate what our SLA looks like, right? We'll give you some sort of a credit if it goes below a certain threshold. Maybe we tie that specifically to the current pandemic. And I've even seen scenarios where you tie that to what the WHO says is actually a pandemic, right? So the question is, when is it actually over, right? Well, I'm assuming, hopefully, the WHO and the CDC in the US have, one day in the near future where they actually declare that the pandemic is somewhat over. It can also be tied to local ordinances. If your local ordinances are allowing people to go back to work, it's kind of hard to say that the pandemic had a lot of impact. But I think these things are fluid, and I think hopefully for the most part, from my negotiations, customers have been pretty sympathetic and willing to work with it, because it's not a situation where someone did something bad, right? It's kind of a situation where, everyone was happy with the scenario. It was just like, you just can't provide it anymore. So I think scaling back and pushing it to an SLA is a good idea, but also potentially having certain carve-outs within the force majeure might be an option too.
So Rhea asked a question that's popular in the Q&A. Again, guys, remember that you can go and upvote questions. Rhea asked sort of a broad question, best practice for early termination provisions. Roman piped up and said, termination for performance and termination for convenience are minimum requirements, in my opinion. Anything you'd want to add to best practices for early termination provisions?
Yeah, so we touched briefly on termination for convenience. Yeah, if you're a customer, I would argue, yes, you want to push for that because you really don't know what the service is going to look like. And if you're locking in the 12 months, that's a considerable amount of money. Obviously if you're representing the company, it's like the opposite logic, right? Hey, like we need the value of our customer. But outside of termination for convenience, you're really looking at termination for other types of scenarios. Like again, we talked about earlier, the performance warranties or even the SLAs, right? Like, hey, I might meet 99% of the time, I'm going to give you a credit. I might meet a lower threshold, I'm going to give you another bigger credit. But okay, look, if you're down for 25% of the month, your service isn't working, right? And so that might be a scenario where it's like, okay, fine. We met that really lower threshold of performance, and so we're going to give you a performance termination. Those are sort of the early termination. Everything else really wraps up into the termination for breach, which I think most people are familiar with. If there's a material breach of the agreement, then or there's a dissolution, for example. Those are all common scenarios where we see your termination for breach. But yes, those are situations where I think, again, it is important to think about, does it make sense to give that for a company that doesn't need to be up all the time, right? If you're just really providing a once a day kind of service or once a week kind of service, it might be kind of crazy to say, hey, look, we were down for 1% of the time and now you get to terminate. That doesn't sound very fair. So I think the business context does matter there. It's hard for me to say, hey, this is market for SaaS because the variants are just so large there. But yeah, it's a good question there.
So Eric asked a question that's getting some thumbs up in the Q&A area. He asked, why would you as a vendor give both a non-infringement warranty and an infringement indemnity? It gives the customer two options in the event of infringement.
Yeah, no, I agree. And if I said that's my mistake, I wouldn't give that if you're a vendor, right? I think from a vendor's perspective, you really want to keep it to the IP indemnity because we're really only talking about third-party liability there. And you're right, if it is in both places, then not only do you have an indemnity claim, you have a breach of contract claim, and you're sort of fighting two fronts there. But what I was trying to say was, sometimes when you're selling to customers with a ton of leverage, they're going to ask for both. And as a vendor, it's nice to say in a vacuum that, hey, I'm not going to give that. But again, you're signing on your first 5 customers and they're paying you millions of dollars. Like, I'd give that in any situation, right? So right. It's really a balance of the business realities. Now, once you're established and this is just customer number 5,000 for you, no way, right? No way we're going to give you 2 bites of the apple like that. So yeah, good spot there. I think that's definitely the right approach.
So Aparna asked the question, you addressed this a little bit, if she's dealing with medical practices that obviously have HIPAA requirements, but they're also a small practice, so they don't have a lot of leverage, right? So how do you, I'm thinking of lawyers dealing with software products too, that take client data. I'm a small firm, so I don't have a lot of leverage over that SaaS provider, but man, if they don't give me this minimum, so how do I win some leverage there?
Yeah. If we're talking about this level of sensitivity, I do think that you do have leverage, right? Like, I don't think it's fair for a healthcare software company to say, hey, we're not going to cover you for HIPAA. That's, first of all, it's illegal, right? Like, the law says that you have to have, in the HIPAA scenario, you have to have what's called a business associate agreement, which is like on your SaaS agreement, then you have like an attachment that's a business associate agreement that basically sets out, this is how we will handle your privacy data, and that all has to be compliant with HIPAA laws. So though, I would say that you know, if a health software provider isn't giving that, that's a red flag, and you should probably say, hey, you know, kindly hint that they should talk to their lawyers about it, because I don't expect them to be signing on a lot of customers in that scenario if that's the stance that they take. Yeah, in the law firm scenario, yeah, that, you know, I think we had a conversation, you know, about a big legal tech company that ran into that situation, but you know, it's difficult because for most legal tech, for most SaaS, you know, you do need the customer data. Again, you know, it's a situation where we're talking about raw data. You know, if you're doing a contract analysis, you need to see the contract clauses in order to build your software. So again, I think the technical discussion is super important. A lot of times, like, I run into roadblocks with attorneys and I say, look, hey, look, maybe we're not connecting on a technical level. Maybe our engineers need to talk about what we actually need to do, right? And if the law firm isn't comfortable with, you know, anonymizing certain of the things to allow the company to do what they do, then, you know, that might be a reality that you have to live with, right? As a small firm. But at the same time, I think it's important to weigh, look, you know, if this software is super important and they're really taking things that aren't, you know, they aren't going to threaten your clients that much, or there's just no way the clients would ever be implicated in that data, that might be something you eat, right? But I those are scenarios where thinking in absolutes is not the best way to go about it. That's definitely a more fluid scenario.
Last question for you, Victor. I'm seeing a lot of questions about insurance. It seems like, especially when talking about data, the scope of risk is so far beyond the value of the transaction. So, like, how would you advise a company insure themselves against that kind of risk?
Yeah, that's a good question. So first of all, you actually mentioned insurance, which is actually that's actually a topic in and of itself. A lot of times your customers will ask for insurance, right? You're dealing with a big company that has a lot of liabilities. They want to make sure that, you know, maybe you're a startup that had, you know, you're bootstrapped and you really don't have any money to cover anything, right? And so
yeah, I
a
think
lot of
AWS
times,
has a requirement for insurance.
absolutely, yeah, they do. And so that might be a scenario where you know, you have to weigh what that premium looks like as a provider. Look, you have to go to your insurance provider and say, look, our customer's asking for $5 million in commercial liability. How much does that cost a month? You know, and then you look at how much they're paying you, and maybe it makes sense, maybe it doesn't. And so it's a tough question. And I think, you know, especially with an early stage startup who doesn't really know what type of liabilities might even come up, it's sort of a leap of faith, right? And so from an attorney's perspective, we really have to lay out what those hypothetical situations look like. You know, what we see as the damages. Again, data breach can be huge. So, you know, if you're entering the world as a healthcare provider in a super sensitive space, you know, that might just be something that you have to think about. You might need to be a little bit more better funded from the beginning in order to play in that sort of game. So unfortunately, it's more of a business reality there.
Well, that's all super helpful. You guys, I'm looking through the questions again. There are a ton. They're really interesting. Please go and email community@lawinsider.com. Contribute if you can as you find these answers. If any of you guys are prompted by these questions for things that you can share, that would be really helpful. So please join the community there. And also, Victor, I just wanted to ask, we had the question from Joy. If people want to follow up with you, that they have questions, you gave us a slide with your contact information, but if you could just repeat that, I'd appreciate it.
Yeah, sure. So you can find me on Twitter. This is how I actually met Mike and everyone. It was just some random silly tweets in here and there. So I'll put that in the chat right now. I'll put my email as well, and so you guys can find it at the bottom.
Perfect. All right. Thank you, Victor. Thank you, guys. We'll see you. And we're doing these webinars the first and third week of each month, the first and third Thursday. So I hope you guys will keep joining us, and also look out for the newsletters on those alternating weeks where we'll feature the work of different Law Insider community contributors. You guys have a good day. Thanks again, Victor.
Great. Thanks, everyone.